Alright everyone, we start off today talking about the ATF's new ban on pistol braces. Well, technically it's not a ban, it's just that you'll have to register a pistol as a short-barreled rifle now if it has such a measure taken, such a brace on it. The first dust-up was about folding braces, I think, and then now they've moved on to any brace or, what you would define generally as a brace that's simply placed on a weapon with under a 16-inch barrel. So now the ATF's classification of weapons has become even more arcane. For instance, if you put a full rifle stock on the back of the handle of a revolver, all of a sudden it becomes a short-barreled rifle. If you have a weapon that fundamentally looks and functions like a rifle of certain lengths, but does not have a brace on it, it's a pistol. Shotguns can only be a certain length for not necessarily fully known reasons. All of this under the auspices of the NFA. This comes from the dark age of the 1930s, back when the government in gangland times was worried about the proliferation of weapons. People were literally mail ordering Tommy guns prior to this, and there weren't really that many problems other than with bootleggers who would have acquired them anyway. The FBI gets formed sometime before, and they're trying to go after Bonnie and Clyde and Al Capone and shit, and now we still have to suffer today, even though things are measurably different now. Again, to be clear, not a whole lot of crimes use this particular kind of weapon. If you're talking about the handgun violence problem in the U.S., it's typically handguns that are on the smaller side, that are more easily concealed, at least under baggy clothing. It wouldn't really make sense to have a pistol with a 14-inch barrel and a brace on it. That would be a lot less concealable than a standard handgun. That is not what is typically used in crime. These weapons often are kind of niche anyway. I like the way that tactical pistols look, although to tell the truth, I wouldn't rue the loss of the brace on it because I think it looks more aesthetically pleasing without it. It does make it more functional. It does add the ability to aim at a larger distance. You have improved the weapon, just to be clear. Aesthetically speaking, though, it doesn't really affect me or any purchases that I plan to make, but it does affect some millions of weapons that are already out there in people's hands that are perfectly legal. It's just now they're getting unlawfully penalized and have to register them as an SBR and pay a fine. They can still keep the weapons, they just have to pay for them. Imagine the people at Demolition Ranch, how much they're going to be offloading. This should be injuncted immediately. The entire National Firearms Act is unconstitutional. I would apply this particular test. Number one, you'd have to look at Bruin. This sort of rulemaking was not comprehended to be anything that the federal government could engage in, although on the lower level post-Crookshank the states were already. At the federal level prior to 1930. That is not ancient history. That is more recent in the development of the United States. An entire century and a half had already passed as a nation before that. It's been a century since, so for more than half of the existence of the United States, the NFA was not a thing. So you're not going to be able to establish, under any prudent understanding of the definition, a long-standing American tradition, certainly not dating back to the time where anyone who was involved with the penning or early interpretation of the Constitution would recognize this as having been part of their way of thinking. They had no such rules. They did not exist until post-Crookshank in any way, shape, or form. It isn't until the 1870s, so the United States is already approaching its fucking centennial at the time. That's number one. And then number two, thereafter, post-Crookshank decision, quite a span of time passes before you get this particular draconian legislation as well. It's not necessary. It's not going to stop any crimes. It doesn't stop the weapons from even being owned. It just basically is a grift to get more money. I guess they're like, hey, we're going to solve part of the deficit by fining millions or tens of millions of law-abiding gun owners for weapons and attachments that they literally already purchased. Yeah, it's a little bit interesting. So Bruin is number one. I imagine they can target it that way. Number two would be the 10th Amendment, arguably. Most states have no problem with such attachments. Where does the federal government get off legislating when the states don't? under the auspices of the 10th combined with the Second Amendment. That'd be number 2. And number 3, let's look at the arbitrary nature of it. Let's say that the NFA is upheld. Let's say that the basic premise of the federal government legislating on firearms with regards to attachments, ammo types, fining, etc., tax stamps, and registration. Let's say that the basic premise is upheld. Somehow Bruin doesn't take effect. The court says, well, it's actually fine because, arbitrary reason inserted here, and that's okay. Where do you actually draw the line on the ability to deploy that? For instance, let's say that you're saying that a short-barreled rifle is what you've created when you have such a brace attached to a tactical pistol. Okay, and you've upheld that. Right now, the tax stamp, I think it's $200 or something like that. What if you were to say it's going to be $20,000? Have you then impeded people? Because for the more poor, especially if that's one of their only weapons, $200 is a lot. This is not going to impact wealthy people, by the way. Some upper middle class gun collector, they can pay a couple grand for their new short-barreled rifles, and they don't really, their Honey Badger or whatever they happen to have, their AR pistol, which is all of a sudden now a rifle. Doesn't make a whole lot of sense, but whatever the fuck. What if you were to up that price considerably so that simply more people are inconvenienced? Effectively, you're making the argument that there's some arbitrary threshold of the number of gun owners within that class that have to suffer before it would become a problem. So the DOJ could up the fine unilaterally. I mean, it's not legislation. It's legislation from the 1930s. Talk about a dark time in U.S. history, by the way, that has simply been compounded and expanded over and over and over again because legislatures that are already dead and have been in most cases for a very long time decided it was a good pragmatic idea. The problem is they passed that legislation prior to McDonald v. Chicago, DC v. Heller, and the Bruin decision. It should be re-examined entirely within that context. I would argue that when you apply a tax stamp or something like that to the operation of a weapon that is not particularly dissimilar from an actual rifle, you create the artificial category of short-barreled rifles because they scare you more for some odd reason. When you create the arbitrary definition and then you say, okay, well, you can have this weapon, but you have to register it above and beyond a normal weapon. You have to pay money above and beyond the purchase of the weapon, etc., etc., etc. That clearly violates the concept of Bruin. It clearly violates the Second Amendment. It's utterly arbitrary. It makes absolutely no pragmatic difference. One thing that I always return to is a libertarian. I'm a pragmatic libertarian. At the very least, if you can make a pragmatic argument for otherwise unconstitutional legislation, at the very least you have an emotional appeal to make. I'm not seeing how this even has that. It doesn't really positively, it's not going to stop any crime. It's not going to save anyone. It's meaningless. It's just basically bullshit that the DOJ has been rambling about for years because for some reason, again, the concept of a weapon fundamentally similar to a rifle scares them. And so they don't have a problem with you owning it, they just want money, effectively. They want it registered. They have a 120-day grace period, by the way, for people, I guess, to remove the brace or whatever, or register it as an SBR. This should be injuncted immediately. It's clearly unconstitutional. The hope is it gets before SCOTUS, and in light of the prior Bruin decision, they say, well, the NFA itself is unconstitutional. Yeah, we're not going to accept any aspect of it anymore. That's what they should have done that long ago. It's just courts are reluctant to take up the case. Rather sad how slowly they move sometimes. That's about all. Peace out.